The clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Good afternoon. The COVID-19 pandemic required many adjustments of the justice system. Social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, do not allow us to hold arguments in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel, but of course there may be glitches that will require patience. Otherwise, we will proceed as we would in person. The arguments are being live streamed this morning, and recording will be available later today. We're ready to hear argument in cause number PD-1233-19, Anthony Rashad George versus the state of Texas.
May it please the court, my name is Robert Udishin and I represent Anthony George. Mr. George was convicted of the offense of capital murder and sentenced to life in prison. Mr. George, at the conclusion of the testimony in this trial, requested that the jury be instructed on the lesser included offense of robbery. The capital murder charge was a murder in the course of robbery. The trial court refused to instruct the jury on the lesser included offense of robbery. The Court of Appeals upheld that refusal in a confusing opinion that both condemned the state's argument that was made at trial that a murder should always be anticipated in the course of a conspiracy to commit robbery. And while the Court of Appeals said that argument by the prosecutor at trial was wrong, the Court of Appeals then turned around and adopted that argument as a basis for their decision in saying that Mr. George was not entitled to the lesser included offense instruction of robbery. As I'm sure the court well knows, a defendant is entitled to the lesser included offense if the offense is included within the proof necessary to prove the greater charge, and if there is some evidence that would permit a rational jury to find that the defendant is not guilty of the greater charge, but guilty of the lesser.
Where do we get that? Counsel, where do we get the valid rational alternative test? What is this? Where does this come from?
Well, it comes from, there's a long line of cases that set out that standard, if that's what you're asking me, Judge. I mean,
is it from the statute? I mean, is a court-made rule or?
Well, the statute sets out in the Code of Criminal Procedure what a lesser included offense is. And so really the first part of the test, that prong number one really comes from the statute. And then I think it's a court-made rule that decides based on the evidence when you're entitled to an instruction. Because the evidence has to, or you shouldn't get an instruction on something just because it's a lesser included offense if it's not based on the evidence at trial. And so I think that's how we ended up with the two prongs. I mean, it's.
I think for a long time, we said pretty clearly that there has to be something to show that if he's guilty of anything, he's guilty only of the lesser. I think we backed off on that a little bit, haven't we, Mr. Udishin?
Yes, Judge Keyser, I think we have, and because saying that he could only be guilty of the lesser is not really a good view of the law. I mean, if you really want to give the jury the opportunity to decide between two rational alternatives, and I think that's how we ended up with the rational alternative kind of proposition, because the evidence in Mr. George's case is a good example of that. You have evidence that and the state spends a lot of time in their brief talking about evidence that would support a conviction for capital murder, while they ignore the evidence that would raise the lesser included offense. But there's really two views of the evidence, and a rational jury could view the evidence in either way. But if you don't give the jury the opportunity to do that, then that's how you end up with the jury not weighing all the factual alternatives that might apply to the case. So in Mr. George's case, there's no dispute that robbery is a lesser included offense of capital murder when you have murder in the course of robbery. And in Mr. George's case, we have evidence that raised the issue of whether Mr. George was guilty of robbery alone and not capital murder. This was a conspiracy case that involved 4 people that committed or were charged with committing capital murder. And 2 of the co-conspirators testified at trial. One of the co-conspirators testified that the plan of these 4 people was only to take money from the alleged victim and not to harm him or murder him. And then another co-conspirator who was actually in the room at the time the offense took place said that Rodney Range, who was one of the co-conspirators, was the one that did the killing, and that he beat and bound Brian Sample, the victim, but that Mr. George did nothing other than stand there. He didn't encourage Mr. Range or assist him or do anything that would make him a party to the offense. And again, what the state's relying in their brief on impeachment evidence that was presented at the trial, because this person that testified that Mr. George didn't do anything had given a contrary statement to the police that said Mr. George was involved in subduing Mr. Sample, but that was impeachment evidence, and unfortunately the trial lawyer never asked for an instruction to limit the scope of that testimony, so it can be considered for sufficiency purposes. But in terms of deciding whether a lesser included instruction should have been given, we shouldn't consider that. We should just look at the evidence that raises the lesser included. So you have evidence from 2 people that say there was never any plan to commit a murder, and that Mr. George did not do anything to assist in what ultimately resulted in Mr. Sample's murder. And then again, thinking about the rational test that we apply, in looking at the evidence, and then I think you have to also take into account that there is absolutely no evidence that Mr. George said or did anything that would indicate that he would anticipated a murder. He didn't bring a weapon. He didn't know that anyone else brought a weapon, because no one did. Mr. Range brought zip ties with him to the scene of the offense. The state kind of blurs the evidence on that in the brief and acts like Mr. George and Mr. Range both brought zip ties. There's no evidence that Mr. George brought zip ties. There's no evidence that he knew Mr. Range brought zip ties. The state also talks about Mr. George bringing a weapon. There's no evidence that anyone brought a weapon to this. So there's testimony from 2 witnesses that raised the lesser included offense, and then looking at the whole record and deciding whether it would have been rational for the jury to find Mr. George guilty of robbery and not guilty of capital murder. If you take the testimony of those 2 witnesses and then all the evidence that is lacking of whether Mr. George anticipated the murder, the jury certainly could have made a rational decision to find Mr. George guilty of robbery and not guilty of capital murder. They just were not given the opportunity to do that.
Counsel, under the Court of Appeals rationale, would that foreclose a lesser included instruction on robbery in every capital murder case where it's alleged capital murder in the course of a robbery?
Yeah, I think that's exactly what the Court of Appeals has done by saying a murder should always be anticipated as a consequence of a robbery. The Court of Appeals has completely eliminated an element under 7.02 in the Penal Code that the state is required to prove in a conspiracy case. And the Penal Code requires the state to prove that the murder was in furtherance of the conspiracy and that it should have been anticipated by the defendant. And so if you take the Court of Appeals reasoning, the state doesn't have to prove that anticipation anymore in a conspiracy to commit robbery, because anytime you have a murder, then that should have been anticipated. And that simply is not the law and can't be the law. I mean, you can't just write out an element of the statute and say the state doesn't have to prove it anymore. And that's really the whole issue.
But we could really we could agree with that proposition and not necessarily agree that there wasn't evidence in this case that would justify not giving the instruction, correct?
You could, but, and that's where I don't want the court to rely too much on the state's brief, because I think the state's brief really ignores the evidence that would justify the instruction. And when the case law for many, many years, is that there just has to be a small amount of evidence, just something more than a scintilla that would raise the necessity to give the instruction. And so you have two co-conspirators who clearly raised it. And then when you look at the co-conspirators' testimony in combination with the whole trial record, it's clearly raised. And what I mean by the trial record, it's back to there is no evidence of any statements by Mr. George, any actions by Mr. George, any statements by anyone else that would indicate that Mr. George anticipated that a murder was going to take place. And there's
So if the deceased was being beaten or in a chokehold or anything like that, and even if the defendant is just standing there, then as a party, he's not responsible for that?
Well, there's a difference between maybe being morally responsible and legally responsible. I mean, he just standing there. Obviously the case law, mere presence doesn't make you a party to murder.
But you were talking about anticipating whether a murder would occur. And if he's standing there watching someone being beaten and chokehold perpetrated on him, et cetera, that would seem to me to be a little anticipation that a murder might occur.
And it could very well be that he was in shock that it's occurring because he had no idea it was going to occur. I mean, I think that's an issue that the jury would have to decide. I mean, that's not a fact that could just be read to say, because he did nothing, he must have anticipated the murder was going to happen. I mean, he was clearly there committing a crime. He was in the midst of committing a robbery, and he had gone there to commit the robbery. But there's evidence under the penal code that said, or there's nothing in the law that says standing there makes him a party to that murder. I mean, he's not assisting, encouraging, or that sort of thing.
Would it make any difference if his awareness of the possibility that a death might occur came to being in the course of committing the robbery or before committing the robbery?
Well, possibly, but then that's back to what is the evidence in the record of that. And so some of the things that the state points to, like pulling the phone cord out of the wall or throwing away the cell phone, are probably consciousness of guilt of a robbery. But if you're pulling the phone out of the wall, I think you're assuming that you could reasonably say that he's assuming that this man who's now been zip tied and subdued, they don't want him using the phone to call for help, and that he's going to survive this, that there's no indication in the record that about anything that happened in the room that would say he should have known that this man was going to die. I mean, that would be a stretch from the record, in my opinion. And really, when you're talking about whether a lesser included instruction should be given, because of the very low standard that's involved in giving it, in some ways it's analogous to whether the state has presented sufficient evidence to support a conviction. If the defense can point to some evidence that raises the lesser included offense, and you're not supposed to judge the credibility of the evidence or whether it's weak or strong or impeached or unimpeached, that you really should view that evidence on the lesser included offense in the light most favorable to giving the instruction, just like you would look at a conviction and view the evidence in support of the conviction in the light most favorable to the state. And the whole purpose of having the lesser included offense that's raised by the evidence is to allow the jury to choose between the rational alternatives. And so what happened in Mr. George's case, because he didn't get the instruction, he was left to argue to the jury that they should find Mr. George not guilty of capital murder, and not because he was innocent and hadn't done anything, but because the state charged him with the wrong offense, and they should have charged him with robbery. And the jury didn't have any opportunity to find him guilty of robbery. But if the lesser included instruction had been given, then the defense argument would have been much different and could have been based around the differences between a robbery conviction and a capital murder conviction, instead of based around a capital murder conviction and no conviction. And it just put the jury in a situation where they didn't have the opportunity to make that factual decision and resolve the only real dispute in the trial.
Were there other lesser instructions given?
There were, and but they were lesser instructions for murder and manslaughter, and that was not the dispute at trial. I mean, there wasn't any dispute. If there was any dispute at trial, it was either Mr. George is guilty of capital murder or he's guilty of robbery or not guilty. And there wasn't any question that a murder took place. It was just whether Mr. George should have anticipated that, and the jury had no way to resolve that. And so it's not kind of what the Court of Appeals and the state do is make an argument. There's all this evidence that supports a capital murder conviction. You can certainly look at all the impeachment evidence and say that it does that, but it just ignores the fact that the only dispute at trial was the difference between robbery and capital murder that the jury was not allowed to make a decision on. And it forced the defense to make an argument that probably wasn't real palatable to a jury, to say, we're going to let this person go because the state charged them with the wrong offense. I mean, they could have been given the opportunity to make the correct decision, and they simply were not allowed to do that by the trial judge. Thanks.
Okay, thank you. And you reserved how much time for a rebuttal?
May it please the court, counsel. My name is Jacqueline Lambert. I'm an assistant DA in Dallas County, and I represent the state in this case. As Mr. Udishin pointed out during argument, Mr. George, the appellant in this case, was charged with capital murder, and the jury was instructed on a conspiracy theory of liability for murder in the course of robbery. Mr. George was a pimp, and he had two prostitutes that worked for him, his girlfriend, Jessica Ontiveros, and Rachel Burden. And the victim, Brian Sample, had received a large insurance settlement and was having basically a party in a hotel room at the Le Meridian in Dallas near the Galleria. And Jessica and Rachel went to an appointment or a date, whatever you'd like to call it, with Mr. Sample. And they observed that he had a large amount of cash. So they came back to the defendant and said he has a lot of cash in the room. And the defendant decided they should go back and they should plan this robbery. So we have 4 defendants that were charged because the appellant recruited his friend Range, who's a larger guy, to help him commit the offense. So Range, appellant, and then Jessica and Rachel were all charged with capital murder. What ended up happening is Range and appellant went in the room. They beat the victim, hit him, put him in a chokehold until he was unconscious. Then they zip tied his at the wrists and at the ankles, basically hog-tied him and put him face down on the bed. And the ME determined that he died from the blunt force trauma and also from suffocating in a pool of his own blood, essentially. And so basically, appellant relies on 2 pieces of evidence to say that he was entitled to this lesser of robbery. And when the jury is instructed on this conspiracy theory of liability, this court has said that that second prong of the lesser included offense test is met only if the record shows there was no murder, the murder was not committed in furtherance of the conspiracy, or the murder should not have been anticipated. So really the only thing at issue in this case is that third prong, whether the murder should have been anticipated. So the appellant relies on 2 pieces of evidence and arguing that it should not have been anticipated. The first is the testimony of Rachel, and she testified that it was just supposed to be a robbery. Well, Rachel's belief about the offense goes to her anticipation, not the appellant's. It's no direct evidence of what he believed or what his anticipation was. So that doesn't entitle him to the lesser. Additionally, this court has held that a prior intent to kill or lack thereof is not relevant if the relevant liability elements are met.
Was there any evidence that those two individuals had talked about the planned date or appointment or crime, whatever?
Are you talking about the appellant and Rachel?
Yes.
Yes, they had 2 dates that day, and then on the 3rd date was when the offense was committed. It was all this occurred in one day. And so Rachel testified that they talked about it after the 2nd date about this plan to commit robbery.
So those two talked about it. Was there any reason why he couldn't rely on that for his lesser included request?
About the fact that they talked about committing a robbery?
Yes.
I mean, I think that is kind of what he's relying on, but what Rachel is talking about is her anticipation of what the offense entailed. That doesn't tell us what the defendant's anticipation is. It only tells us about hers. So it can't be attributed to him. And it also goes to this court's holding that, even if the parties initially planned only a robbery, that's irrelevant, because if the relevant liability elements were met during the course of the offense, then what they planned beforehand is really irrelevant. Really, we're just looking at whether it should have been anticipated.
Whose burden is it in a case like this to establish that someone should not have anticipated or should have anticipated? Can you talk about the burden a little bit?
I think that when he's requesting the lesser, the burden's on him to put evidence before the court to show that he's entitled to it. I think on appeal, the court is just looking at the evidence as a whole. I don't think that the burden is on either party necessarily. It's just looking at the weight of the evidence to determine whether it was there, to determine whether the trial court, abused its discretion in denying the lesser.
So your position is that once they started beating the deceased and tying them up and, face down in a pool of blood, the anticipation is met?
I mean, I would argue that the anticipation was there before all of that started. That recruiting range, he actually anticipated the murder before he even went. I think he anticipated that the complainant was going to fight back. The girls told him that he was using drugs, he was behaving erratically. They expressed concerns, telling him to be safe, be careful, because they were worried there was going to be a fight. And then I think all of his actions leading up to the offense, during the offense, and after show that he should have anticipated. They turned the radio up, the music up on the television so that the scuffle wouldn't be heard by anyone else on the floor. They put the do not disturb sign on the door. They ripped the cord from the wall and so that he couldn't call for help. There was no indication that they checked his pulse before they left, that they called, 911 to report a robbery that had gone too far. In fact, they stole his cell phone so that he couldn't call for help. They left him hogtied. So even if he regained consciousness, he couldn't help himself. He couldn't get out of that position where he was face down in the pillow, suffocating. And so to me, that shows a clear intent. They intended to leave him there for no one to disturb him so that he would die.
So your position then is that you would say that the Fifth Circuit's opinion isn't really in conflict with the lower courts because the evidence here showed some indication of an anticipation of the murder.
Absolutely. So I think that the problem is that when you look at the facts of the case, the facts are in line with the court's holding. And I don't think that there is a conflict about that. I think that when you go in and commit a violent crime like this, you should anticipate that a murder will occur. I don't think you can say that in every case. And I don't think that's what they're saying in this case. I think that they're saying based on these facts. They do a very in-depth analysis of the facts during their sufficiency review. And then they only recount those facts briefly in the lesser included offense analysis. But their discussion of the facts is there. And all of his actions before, during, and after show that he should have anticipated the murder. And that's what supports the court's ruling.
Can I ask you a question about facts? Since you're talking about facts, I think the defense is saying that at the time this beating was going on, the appellant was just standing there watching. You said just the opposite. You kept saying they beat him up, they did this and they did that. So is there evidence that the appellant was actually taking part in the beating?
There is evidence of both. Jessica wavered in her testimony. She testified that he did participate. She testified that he didn't. So there's evidence of both. So certainly his relying on her testimony, I understand that if she said it, it's a scintilla of evidence. However, even if he was just standing there, we have lots of other evidence that shows what he did afterwards. So even if he didn't participate in the tussle, he didn't check him before he left. He didn't call 911. He is the one shown on video disposing of the victim's cell phone. The other evidence showed that he was the pimp of these two girls. He controlled everything they did. He was the one who set the plan in motion. So there's lots of evidence in the record indicating that he was the leader, he was in charge. So even if he stood there while Rodney, participated in the tussle, there's lots of other evidence showing that what he did afterwards shows that he should have anticipated the murder, or that he in fact did anticipate the murder.
Okay, let me ask you then about the anticipation part, because, I think Judge Hervey was asking you if the anticipation that's required in this case, that the anticipation once the victim is getting beaten to death, if anticipation starts right then, is that good enough? Or does the anticipation need to be, as at the point when the appellant decided to take part in a robbery? And you already said something that made me wonder what your stance is there.
I think that the court's ruling in Russo and some of the other cases cited by the Fifth Court of Appeals basically says that there doesn't have to be a prior intent to kill, and that as long as the relevant liability elements are established at the time the crime was committed, then that's evidence to show should have been anticipated. So as long as we have those relevant liability elements at the time. So at the time that they started beating the complainant, or if you want to adopt a portion of Jessica's testimony and say at the time that Range started beating the complainant, I think that those relevant liability elements were established. And so I think that from that point forward, we can say that, but I believe that the evidence shows that his actions before actually showed that he should have anticipated it.
And those actions would be bringing Range?
Along with the fact that he parked in a different spot than he had the previous that day. He changed his clothing. He wore a hoodie so he could cover his face. He wore gloves. He's seen on the video surveillance using his elbow to push the elevator button so that he wouldn't leave fingerprints. They brought the
Yeah, but wouldn't he take all those actions to hide a robbery too?
Right. That's exactly what I was going to ask.
Potentially, yes. I think that's probably a fair argument. But we don't know what's in his mind. I mean, if he was planning a murder from the get-go, that also supports, it also shows that he should have anticipated the murder.
Okay, and I want to be a little nitpicky here, because you said a minute ago that at the time the beating started, there was definitely anticipation at that point. So what about 1 second before the beating started? After the beating started, I agree with Judge Hervey. If that's the rule, yeah, there should be an anticipation, but 1 second before anybody started beating him, should he have anticipated at that point if he was not taking part in the beating?
I think that his actions before show that he should have anticipated it. So I sort of feel like this is an abstract concept that the court hasn't really addressed before about the precise moment. When the appellate court or a reviewing court is looking at the evidence, they're looking at all of the evidence to make this determination. Right. So it's sort of hard to separate out the moment, if that makes sense. Am I answering your question?
You are to some extent, but I think that it may be very, very picky here about the anticipation. It could be that, at the time the beating started, that he actually should have anticipated, but prior to that, not. Now, I know your argument is that you think the evidence is clear even some time before that, but what if we really look at the evidence and disagree with that? What should the rule be?
I think that you have to look at all the evidence. I don't think you can look at one particular moment in time to make that determination.
Let me ask you one thing.
Go ahead.
One thing that you said that really could apply both ways. You said that he was a leader and he pulled the phone out of the wall and he took the cell phone away. Yeah, it could be that he couldn't call for help to save his life, but it could also be taken as, he anticipated that he'd probably live through it and he didn't want him calling. That equally to me, I don't think it shows much other than the fact that he was a leader as far as the offense was concerned, and getting the bigger guy in there to kind of as an enforcer, it would be a little bit more evidence that he anticipated that at least serious bodily injury might be involved, or death. I don't know. We'll see.
But when you leave him face down, tied up in a pool of blood, that might push it a little further down the road.
Well, yeah.
Counsel, the state prosecuting attorney has suggested that we can reconsider the entire Saunders framework. I wanted to see if you have anything you want to add or comment on about that argument.
I don't really have anything to add to the SBA's amicus. I would say that my reading of Saunders is that it sort of leaves this issue of harm open to a reviewing court. If a defendant is given intervening lessers, between the charged offense and the requested lesser that was not submitted, that can be evidence that not giving the lesser was harmless. The flip side of that argument is also that if he's not given any lessers, that the jury might be faced with this situation where it's either conviction for the greater offense or acquittal. And so they might find him guilty of the greater offense. And so that could be evidence of harm. So I see the problem with the rule. I think the SBA is basically arguing that when they get intervening lesser offenses, it should always be harmless. That's the way I read the amicus. And I mean, I certainly think that in this case is a perfect example of when you get the intervening lessers, then not getting the robbery is harmless. And so I don't know that doing away with Saunders is necessary, but I do think there could be some clarification on how it should be applied in assessing harm. The one thing that I would point out is that when you're doing a harm analysis, you look at the entire state of the evidence and the jury charge. And interestingly, if you look at the closing argument of defense counsel in this case, he doesn't argue that, he argues that the defendant is not guilty of any offense. He argues that the state didn't bring any credible evidence, that Jessica and Rachel were liars, they weren't credible, that they weren't corroborated, and so you can't consider their testimony at all. He flat out says during closing argument, the only person who said it was a robbery was Rachel, and she's not corroborated, so that's not credible. And he basically says that the video shows the defendant was at the hotel, but you can't put him in the room, and you can't even prove that he was there during the offense. And so it's interesting because if that's his position, then having another lesser for robbery wouldn't have changed the outcome. He would have still argued that he was not guilty of anything because the evidence wasn't credible. So I think that also goes to the harm argument that it was harmless in this case. The jury was admonished, or they were in voir dire, the capital, murder, and manslaughter role explained to them and the punishment ranges. And then all three of those offenses were given in the charge. So if they had believed that he was guilty of some lesser than capital, they had a viable alternative because they knew that capital was going to come with that mandatory sentence of life imprisonment without parole. And if they had believed that he was not guilty of that greater charged offense, they could have found him guilty of a lesser and given him a lesser sentence, and they didn't, which indicates that any error in not giving a robbery instruction was harmless in this case.
Ms. Lambert, I have a question for you to consider. Clearly, the state has the right to its discretion on what cases to prosecute and which defendants to prosecute for crimes that are committed. And so my question is, should it be something that we should consider that what the state was looking to do was seek justice for the death of this individual versus the property crime of stealing or robbing? It was really more to seek justice for the death, and so that really it's not about the robbery aspect of it. It's about the murder aspect of it. Is that something that should be considered when we look at what's appropriate for a lesser included offense?
I think that really you're supposed to look at the evidence when you're deciding whether the lesser should be given. But I think that when you're looking at the harm argument, that's certainly relevant because the appellant's trying to argue that, you know, really it was robbery, but we have a dead body. We have a victim who would not be dead but for the actions that the defendant set into play. And so absolutely, I think that goes to, and you know, doing a harm analysis as to whether would robbery really have made a difference in this case. You know, would that lesser have changed the outcome? I don't think so. And I think that it's interesting because the state actually didn't really have I mean, we were forced to trial in this case. He was offered 20 years, he turned it down. And so we're forced to go to trial on the case. And yes, it is about making sure that the victim's family and that the victim gets their day in court because he lost his life because of the actions of the defendant and his accomplices. And so I just think that plays more into the whole state of the evidence and the harm analysis. I think when you're talking about whether a lesser should be given, really that's more the evidence that was presented at trial and whether, you know, the trial court in its discretion decides that that should be given.
Can I ask you this? Since you're saying that the record here did not raise robbery, what kind of evidence would it have taken? What do you think would have raised robbery?
Well, certainly the defendant's own statements would raise robbery. He's relying on statements of others, which, you know, Rachel's statement about what she believed is not relevant to what he believed. And then,
but those are statements that were made in the context of a conversation with the co-defendant, correct?
Yes.
Okay.
But the way that the testimony came across is, I thought it was just supposed to be a robbery. So it's basically like what her interpretation and her anticipation of the offense is. She didn't say, he told me it was only going to be a robbery. She said, this is what she thought it was going to be. And there's other evidence that indicates that the defendant, you know, potentially had other plans. If you look at the sufficiency analysis, also, the Fifth Court of Appeals finds him guilty as a principal, as a party, and as a co-conspirator. They find the evidence sufficient under all three of those grounds. And so they basically found it sufficient as a principal that he's the one who went in and did, who actually participated in the assault. And I see that I'm out of time. So unless the court has any further questions for me.
Thank you, counsel.
Thank you.
You know, I have 4 minutes, and let me try to address a number of issues that came up, and maybe I want to start with the fact that Ms. Lambert admitted in her argument that the evidence can really be viewed different ways, and that's at the crux of this whole case. I mean, if you,
Mr. Udison, let me just ask you, give me your strongest point on why your client, how he raised the lesser included, given all the arguments we've heard.
So it was raised through the testimony of two witnesses who were both co-conspirators, and it's one of them was Rachel Burden, who was a co-conspirator who helped plan the robbery with Mr. George, who testified that the plan was to get money and not for anyone to get hurt. And to argue with that testimony that just goes to her state of mind really ignores the whole law surrounding co-conspirators. I mean, the state obviously uses co-conspirators' statements and testimony to show what all the conspirators were thinking and planning and doing. But the state wants to kind of ignore that and say that doesn't have anything to do with Mr. George. But certainly that testimony could be used on whether he anticipated a murder, and the jury can draw inferences from that. The other testimony is from Jessica Ontiveros, who was in the room, another co-conspirator who was in the room when this offense took place, who testified that Mr. George did nothing to assist or participate in the subduing of the victim. Again, there was impeachment testimony of Ms. Ontiveros where she gave contrary statements to the police, and that's what Ms. Lambert is referring to. But when Ms. Lambert says, as she did in her brief and in this argument, that they beat Mr. Sample or they brought or zip tied him, there is no evidence of they in terms of the trial testimony. I mean, that's drawing bits and pieces out of impeachment testimony that, again, unfortunately, the trial lawyer did not ask for a limiting instruction on that testimony, or we wouldn't even be talking about it in support of a sufficiency question. But we have testimony from two people that raised the lesser included offense. And then you have no other evidence in the record. And I agree with Ms. Lambert on this. You have to look at the whole record. There is zero evidence that Mr. George or any of these co-conspirators made any statements that would show an anticipation that a murder was going to take place, that anyone brought a deadly weapon with them. I mean, if you say that bringing Mr. Range as a co-conspirator or robbery shows some anticipation to commit a murder, that again writes out an element in the conspiracy statute. Anytime you have a conspiracy and you bring someone with you who's part of the conspiracy, then there's no need to show anticipation. It just makes no sense.
I didn't mean to take all your time. Go ahead and finish what you
Well,
were saying. That answers my question.
I'm sorry, I want to address Saunders real quickly, because really what Saunders says, and I think this is still good despite everything that the state prosecuting attorney says, because about Beck and Shad out of the Supreme Court, Saunders talks about it is not invariably true that a jury's rejection of one lesser included offense will render harmless the failure to instruct on another, and that a jury needs to be given the opportunity to resolve the factual dispute at trial. And that's what we did not have here, despite what Ms. Lambert says about the argument that was made by the trial attorney was because that was the only argument he could make, because there was no lesser included offense instruction. I see I'm out of time.
Were there two more points you wanted to make?
Well, there was a number of things that Ms. Lambert said. I think that I don't think are correct. That I think the briefs address them. I don't want to take up more of the court's time, but if the court has questions, yeah, I'm happy to answer those.
Okay, thank you, counsel.
All right, thank you. Thank you.
The case is submitted and the court stands in recess. The clerk will adjourn the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.